today what we're going to talk about is employment law and labor law. And I know that everybody at home, I know that it's everybody's dream to start your own business, and not just to start a business, but to have a business that dominates and that is big and it grows and it takes over. Well, if you're going to do that, you're going to have to pay lawyers, and you're going to have to listen to what they say, and you're going to have to do what they say, because there's a lot of traps out there for employers. And so that's where lawyers like Laura come in. She is a labor and employment attorney. She works for a group called Clark Hill. I say a group, they're nationwide. They do a lot of very different things, among which is labor and employment law. But they're a group that you can turn to when your efforts at dominating the world are coming into problems, complainers, whiners, people who are like, hey, I want to sue you people, or hey, I feel like you guys are ignoring my rights. Laura is one of the people who kind of show those people their place and say things like, we're going to tell you how you're going to feel. We're going to tell you what you're going to do, and then we're going to tell you how to feel about it. So Laura is an employment lawyer, and after this sort of very dire introduction, I'm going to allow Laura to introduce herself and talk a little bit about her labor and employment practice. And I told you, I tricked you into coming on the podcast. You thought you were going to be able to talk about yourself just a lot, and you will. But I don't want you to have to cram it within 30 seconds, but tell the jury, tell the jury a little bit about who you are and your practice area.
Yes, thank you, Jeremy. I appreciate your having me here today. This is my first podcast ever, so I'm honored that you would have me as your guest. Again, my name's Laura Calhoun. I'm board certified in labor and employment law. I've been practicing law. It will be 30 years this December. I can't believe it, but it's true. As you might imagine, I have seen all kinds of things over the last 30 years. It constantly amazes me what people do in the workplace. I'm always like, aren't y'all supposed to be working? Like, what is going on? So it's a very interesting area of law, and again, I'm currently at Clark Hill. I've been there a little bit over a year now. It's a great firm, as Jeremy said. It's national. We practice all different areas of law, but I currently represent management in employee issues. So,
if you had to pick, and just so we're going to start off slow today, and then we're going to get the snowball on the top of the mountain, and we're going to push it down, and the snowball is going to get bigger and bigger and bigger, and it's just going to be unbearable how great this is going to be today. We have 57 minutes and 45 seconds, and this is just going to be the greatest. So let's start here. I told you I was going to zap you with some questions that you just didn't expect. Number one, what is your favorite statute and why?
My favorite statute?
Your favorite employment statute. If you had to choose one that you were like, this thing helps.
Well, I think Title VII.
Okay.
It's the national statute that prohibits discrimination based on race, sex. It actually doesn't include age or disability, but those are good statutes too. Mm-hmm. But religion, it covers it's the main anti-discrimination statute that governs all of federal law, and what most of the states have similar laws that pretty much mirror Title VII.
So and that's Title VII. Check this out, Laura. This is about to be big. You're about to be like, oh my God, Jeremy, you're just even more than just a criminal lawyer. Title VII of the 1964 Civil Rights Act.
Oh, yeah. You're exactly right. And that's really the statute that came in and changed the landscape of employment law. Because, prior to that, it wasn't unlawful to discriminate against people based on their race or their religion or their sex. And so it really changed things, and it's a phenomenal statute that gives a lot of people protections that are very well needed.
And maybe something that probably gets more publicity and more. And I know that you don't practice, or you may not practice in this area. Maybe you do touch it, but Title IX, people are very familiar when they hear the words Title IX. They understand that that does the same thing, but with regards to education.
Exactly. exactly.
Do you guys ever, I mean, and I don't know that you would necessarily do that. I guess if you were dealing with a public institution.
Right, right. And yeah, I don't usually delve into Title IX cases. There's other lawyers at my firm that I would pass that off to, but it is the same idea.
Okay. And you've also developed a bit of a sub area that you were. I saw it on your website. You kind of downplayed it when I was talking to you personally, but I don't know many folks who do who advise veterinarian practices, in particular veterinarian practices on employment law. What kind of issues can happen there?
Well, all kind of issues, and I'll say in full transparency, my husband's a veterinarian, and so that's how I kind of got my foot in the door in the veterinary world. They tend to be a fairly tight-knit group, and so I kind of have a personal understanding from my husband's business, and it kind of evolved into representing a number of veterinary practices really in the area and really throughout the state. I would say that they have problems just like every other business. Most of them are smaller businesses, but they still have employees. And so, and many of them have, once they hit that 15 employees, then Title VII and the state anti-discrimination laws come into play. So they've got a lot of legal obligations. And a lot of times, what I found is they oftentimes just didn't know where to turn or what to do. And veterinarians, as with a lot of employers, they may not be intending to do anything wrong, they just don't know. And so it's been a nice little practice area for me to kind of get to know them. Most of them, they're very nice people. So, and they generally want to do the right thing. So I've represented a bunch of them over the years and really enjoyed it. But, they've got issues really a lot like everybody else.
Just like everybody else.
Yeah. In fact, one of the things, kind of to one of your initial points about, you start your own business and you do all this stuff and you're excited and you've got an idea, and then suddenly you've got to have employees. And one of the jokes we always say in employment law is, there's an old gypsy curse of I wish upon you one employee, because that's all it takes sometimes, to just cause problems if you don't know what you're doing. So
right. So and you mentioned too about the 15 employees.
Yes.
Talk about that and talk about how that's relevant more, or talk about why that's relevant and any changes that. Yeah,
exactly. So, really, under Title VII, which is the federal law, and our state equivalent, Chapter 21 of the Texas Labor Code, you have to have at least 15 or more employees to be liable under those particular statutes for the anti-discrimination laws. And there is so that's important. But recently, so just effective this September in Texas, our state statute was amended to have a special exception for sexual harassment cases. So if all you have to have is one employee under this amendment to the statute, it only applies to sexual harassment type situations, but you're going to be liable now under the statute, where at the beginning of this year you would not have been. So really all Texas employers now need to be aware that even if you only have one employee, you need to have your anti-discrimination posters up, you need to have your anti-harassment policies in place, because you're going to be potentially liable. And the other thing about this statute, which is different than before, is it leaves room for individual liability. So typically before, if you've got a supervisor that's sexually harassing one of your employees, you as the company can get sued by the employee for sexual harassment, but the actual harasser is not individually liable under the statutes. But I think that's going to be something this new statute leaves room for. So.
And okay, so what you're saying then is that so it used to be that an individual who was, if they were claiming sexual harassment and the employer had under 15 people, and so everybody knows there's games that people play, right? Well, these are independent contractors. You're not an employee.
True.
The courts kind of cut through some of that. Am I right about that, or no?
Yeah, no, and that's still a distinction. So under Title VII, independent contractors aren't considered covered employees, so that
Okay.
can be a defense. One of the things that often gets argued is, well, you've been improperly classified as an independent contractor, so they really are in actuality an employer, and so that comes up in a lot of cases. Also under like the Fair Labor Standards Act, when you got overtime claims, that's a huge issue. If somebody employer's like, oh, I'll hire you as an independent contractor, you work all these overtime hours, I don't pay you that because I don't have to pay an independent contractor overtime. But then suddenly, the employee gets fired, and then they turn around and say, well, this whole time I should have been an employee, and now I want all this overtime. So it becomes a dispute.
An issue, yeah.
And that area of law, overtime independent contractor classification, there's a lot of gray, and there's been a lot of changes, and there's like 3 different tests depending on, are you in front of the IRS, are you in front of the Workforce Commission, are you under Fair Labor Standards Act case law? So it's a very confusing area, and a lot of employers screw it up. They just don't, a lot of times they don't realize it. As with a lot of the laws, they don't mean to be messing it up, but they are. So
yeah. So if you had under 15, then a person trying to sue you could not do so.
yeah, you would have a defense.
Okay. And now,
And there are exceptions to that.
Right.
Obviously in the case where there's some exceptions of like sexual assault, and so there's a few, but generally for any of the discrimination, if you've got under 15 employees, that would be your defense.
okay.
So,
And now, but the other forms of discrimination you're saying would not be covered. So in other words, if somebody said you're discriminating, you have 14 employees, and you are discriminating against me because of the color of my skin, that person's out of luck.
right.
Okay.
And I don't know why. I don't know why they didn't just apply it to all the protected statuses, but they didn't. So,
Well, Texas, our legislature in Austin, they don't do a whole ton. They don't create a whole lot of causes of action. Well, in some instances they do, but in most instances they really don't. I mean, they're very, by and large, very hostile to lawsuits, and very protective of employers.
yes, I would agree.
So it's interesting to me that they've carved anything out, frankly. But
Yeah.
but they've allowed this one, and now they're saying that you, Johnny Harasser, the Mr. Salesman at the car dealership, you deal with a lot with car dealerships.
Well, I don't want to throw them under the
you don't
rug.
have to-
It's it amazes me, like I said before, what goes on, and but there's it happens a lot.
Sure.
So
And so, but now you're saying that I can sue the company and you.
yes,
But in reality, there's probably not a lot of pockets there with the
that's often
supervisor.
the reality.
But
There isn't, but it is good though that that there can be a different avenue, because before, you couldn't sue them civilly. Now, maybe if it was a case of like sexual assault or something like that, there could be criminal implications, which you've probably been involved in, when the sexual harassment really evolves up to sexual assault. Then there's criminal liabilities.
And you have, so, and do you handle cases like that where, so let's say there is an allegation of a sexual assault. Let's say it's at, and I can see your employer getting wrapped up, or your client getting wrapped up in it if, say, it happens on the premises, or it happens in the course and scope of somebody's employment, or that's the allegation that it happened.
Right.
And then they say, well, I'm going to sue this guy for sex assault, and company, you negligently, would it be negligent supervision? How would they try to tie the company to that?
Yeah, that would be generally a negligent supervision, or even negligent hiring, or negligent retention if the guy has a history of something like that. But really, under our statutes, a lot of those claims get preempted by if it's sexual harassment. So that can get a little complicated, but
Okay. So in other words, you could come back and say, well, no, you're really bringing a sexual harassment claim here, and you're kind of trying to mask this up as assault.
yeah, and it preempts
Okay.
the torts.
there's some smart lawyers out there, but the good news is hopefully lawyers getting paid everywhere, because every time a lawyer gets paid, an angel gets their wings. You've heard that, right?
I haven't, but I like that.
I mean, it's just reality. It's true, right? I mean, there's no higher calling. What is so 2021? What are the big pickles that Laura Calhoun, attorney at ClarkHill.com, gets called on?
Well, I would say the biggest thing last year and this year, it's COVID. And it's all about COVID.
Is that
yeah, you might have heard of it.
I've read about this. Yeah.
Yeah, it started with I started working at Clark Hill on March 9th, 2020, right before the pandemic hit. And so it has just been full speed ahead since then on all of the federal leave laws that were initially put out at the beginning of the pandemic. And then, after that, it's been just kind of evolving into the other laws that have kind of picked up on the initial leave laws and how do you handle that. And then, of course, issues of masking. And now the big thing is vaccines. And so that's everybody right now is waiting to see what OSHA's going to do with President Biden's mandate to have this, everybody with 100 or more employees is going to have to either have everybody vaccinated, or if you're not vaccinated, you have to go through weekly testing. So there's a big question mark on a lot of the kind of details of that. He kind of put a broad stroke out there of here's what I want to see, but really we need to see what OSHA's going to come out and say as far as what is actually going to be required of employers. But I'd say that's the biggest issue right now for if you've got 100 or more. Everybody's wondering when do we have to have all this done? How are we going to do the testing? Who's going to pay for the testing? Do you pay for your employees' time while they're waiting to while they're going to get tested? Biden has requested that employers pay the time for employees to go get vaccinated, and also give them paid time off if they have a reaction after the vaccine. And that's what was actually part of the leave laws that were in place this year too, to provide for some coverage on that. But that was optional, so employers could opt out. But with this new rule, if OSHA is coming out with it, then they're going to need to comply. So it'll be interesting to see what they do, but that's the biggest question right now that everybody's dealing with.
So for the jury, and this is your camera. I didn't tell you that earlier. Okay. That's your camera there. I make all the guests sit on that side because this is my good side. My other side is horrendous. We can't. I did it once, and I can't even watch it.
It was bad, huh?
Well, they're all bad, but this one was worse. So explaining to the jury, to everybody at home. So the president was it an executive order that he signed to do this?
No, I think it was more, I don't know if it was an actual executive order or if it's more just a mandate to OSHA.
Okay. And so that's binding on OSHA to get this done? Is that what that means?
Well, OSHA's indicated they're going to do it. And so,
and that's the Occupational Safety
Health
Administration.
Yes.
Okay.
Yeah, so, and they're the ones that are in charge of workplace safety. So if your workplace, if you've got safety violations going on, or somebody gets injured or killed at your workplace, OSHA is the one that would be coming in and investigating, issuing fines, or that kind of thing. So, so they're in charge of workplace safety, and every employer out there, OSHA has what's called a general duty clause, which says every employer has an obligation to make sure that they've got a workplace that's free from hazards and dangers. So you've got a duty to provide a safe workplace.
Question for you: can I require my employees to walk over hot coals? Is a motivational tool in for training?
I don't think I'd recommend that you require that. I think if you're doing a little team building,
that's what it is. And they're independent contractors, so
yeah. I'd be careful. There have been many lawsuits over team building events. So
okay. I bet I'm sure there have been. We talk about in conferences and little, things like that, right? I'm sure that's just a breeding ground for that stuff. Yeah.
Oh yeah.
Okay. So back to the OSHA thing. So you were saying that OSHA has kind of indicated that they're going to carry this out.
Yes. So haven't said when, but Biden's like, he wants it sooner rather than later. So the expectation is that it will be rolled out here fairly soon. People are thinking in the next couple of weeks maybe. And then the question is, how long do employers have to make sure that they're complying? So I think it was the retail industry, one of the industries has requested that OSHA give everybody at least 90 days. But
it'll in compliance.
Yeah, it'll be up to OSHA to determine that. But it is going to take some time, because if you've got somebody who's not been vaccinated, unless they go get the single dose shot, then they're going to have to get the one and then wait, and then you got to wait 2 weeks after that. So it's going to take a while to get everybody compliant.
What type of questions are your clients asking you about this?
Well, a lot of them deal with, and this was even before the new mandate, but a lot of them deal with, what do you do? Well, the first big question before this was, do we mandate vaccinations or not? And then, so what they grapple with is, well, we can, or do we just want to encourage it but not require it? And one of the things is that if you're going to require it, then you're getting into issues with your employees that are going to object, and you get into the reasons why they're going to object. And if it's based on a disability or a religious belief, then the employer has a duty to engage in the interactive process with them to see if they can provide a reasonable accommodation. So can something be done if we're going to require everybody to get vaccinated, but I come to you and I say, well, look, I can't get vaccinated because I've got a disability. So you've got to be able to determine, all right, well, what do we do? If they can't get vaccinated, then what? And that's the big question. So if it's a disability issue or religion, can you accommodate? The biggest, easiest accommodation is, can they work from home? I think that's one of the biggest things that came out of this pandemic is everybody realized that there's a lot of productive work that can go on remotely. And so I would say now that's going to be something that really, like the EEOC just filed, I think, its first lawsuit on this, of denying somebody work from home as an accommodation. So I think you're going to have to really be looking at what can you do to accommodate the employee. And then what do you do if they have a job that they can't work from home? Well, it's all very case by case, and sometimes you got to be creative. But EEOC is very much encouraging you to be creative. And same thing with the religious belief. So EEOC is... they've basically come out and said, because there's a lot of different religions out there, and that people have varying beliefs, but it's got to be a sincerely held belief to warrant an accommodation. So you can't just make something up, or it can't be some personal opinion.
Can I get it on the internet, like my no?
Well, there's a lot of things that you might question or you might not have heard of.
I've gotten my flu vaccine every year, but this year this became a no for me. We can't. It's got to be a sincere.
It's got to be sincerely held. But what EEOC has said is they really want you to just assume that it is. So they're like, even if it's something you've never heard of, if it seems like it fits in the category of something spiritual, that sort of thing, it can't be based on a political belief or something like that. But they've gone and they use the word assume that it's sincerely held. So then employers are really in the next phase of, can we accommodate?
Well, wouldn't they just fall into that category of having to do, was it weekly testing?
Well, and that's where under, I think, this new rule, that would be something you could do. So the question is, and again, I think there's some question, still employers may still be allowed to just have a mandatory, and are they going to be able to opt out of this weekly testing requirement? So that's a little bit of a, is the testing going to be a required option that employers have to offer? But that could be potentially, yes, a way to accommodate somebody based on disability or religion or pregnancy. That's the other thing that EEOC has said is ordinarily pregnancy itself isn't considered a disability. You can have medical conditions and stuff related to it that might fall under that, but generally it's not. But what they've said is, for purposes of the pandemic, pregnancy needs to be accommodated just like any other disability or religious belief. So those are sort of your categories of what you deal with. And I say that's a lot of the questions that I'm getting is how do we handle the whole vaccine? Because a lot of employers want to mandate it, but they don't necessarily want to have to get into all the accommodation discussions and questions. It just kind of opens them up to some liability, because if they screw it up, then they can potentially be liable. Whereas if they're just encouraging the vaccine, then they're not getting into those discussions of why or why not are you getting vaccinated, because you're not asking anybody. It's just a.
Well, I would think though that in some ways, if it's a mandate, right? If it's an OSHA, if it's a legal requirement, I would think that could. You tell me. It sounds like it could or ought to absolve liability, right? Depending on if somebody gets a vaccine and they get injured, or if somebody gets the vaccine and they get ill, whatever the case may be. It sounds like, well, that's not our fault. The law required us to make you do that.
Yeah. And again, we've got to see what they come out with. I mean, my thought would be is they will allow for those exceptions for the accommodations for the disabled and the religious beliefs.
Does anybody say it's against their religious beliefs to get tested, to have the thing?
I haven't personally encountered that they can't do the testing, but definitely getting the vaccine. I mean, that's a big one. So, so no, I haven't seen that on that, but that's not to say it hadn't happened or somebody might not say it. And then you would deal with it case by case of, okay, well, if you can't do the weekly testing and you're not going to get vaccinated, then what? And really the answer in these cases has been, you just need to find somewhere else to work.
Yeah,
and that's the harsh reality, and that's what a lot of employers kind of hesitated doing mandatory, because we don't necessarily want to fire people, but if we have this rule and they don't have a reason for a legal accommodation but they just don't want to get vaccinated, well then you're going to let them go.
And you can make from the employer standpoint, you make the government the bad guy. Right. I mean, if there's an employer out there who really, we kind of want to do this, and then if it's the boss who's saying everybody here, all of you 100 people have to get vaccinated, then you're the mean guy. You're looking to pick some probably political fights with some of your employees and some of your people. Whereas when it's the government coming in, you can just say, hey, it's this is Dad's rule, not mine.
Yeah, I mean, I think so, because it is. I mean, you're not going to have an option there.
Big Brother's rule, yeah. So
yeah.
Okay, what is something that every lawyer ought to know about employment law in 2021? So, like Jeremy, criminal law attorney, what am I likely to get asked at a cocktail party? Because I party a lot. I go. It's crazy. But if I get asked a question, what should I know about the space that you're in? What's easy enough for me to remember and yeah. I'll tell you the criminal one after this. Okay. Something every lawyer needs to know about criminal law. But go ahead.
Well, I would say probably right now the biggest questions are COVID related. And hey, my employer's trying to make me get vaccinated. I think that's what a lot of people are saying. And I'm scared. I don't want to get vaccinated. It's stressing me out. Can they make me do it? So I think that's going to be a big question. And that's the one that I see a lot is, hey, can they make me do this?
And the answer is yes?
The answer is yes. Unless there's an exception and for a disability or religion or you're pregnant.
Okay.
All right. So that's really probably the big one. I would say the other thing that just lawyers should know about employment law in general is it is very unique, very specialized area, as all laws. I certainly don't try and practice criminal law at all. I refer people to you. But
did you hear that, ladies? Everybody, this is yes.
I do. But I would say it is very unique, and there are a lot of traps and things like, if you do have a sexual harassment case, I think that's probably what a lot of people get questions about too. I think I'm being sexually harassed, or I'm not sure. Is you've got to go through, there's an administrative process. You have to file a charge with either the EEOC or with the Texas Workforce Commission Civil Rights Division, and you've only got so much time to do it. You have to do it within 180 days if you're going to file with the state, or 300 days with federal. Our new Texas statute, though, gives you the additional 300 days if you're the one employee sexual harassment. But you've got to go through that. You can't just haul off and file your lawsuit. So there are a lot of, and then there's time limits after you're through the administrative process. So there's just a lot of little traps and things to know if you don't practice in the area that you might not be aware of. So.
Okay, is the Texas new statute, is that going to be retroactive? Do you know?
No, it would be moving forward.
It would be moving forward. Okay, so somebody can't come and say, I got harassed within the 300 days, but that was before September 1st.
Yeah, I don't think it's retroactive.
Not going to be able to get there. Okay. So you do, what other areas of employment law? Well, let me back up. How about this? With COVID, have we seen a drop in sexual harassment claims with at-home working? How has that impacted a lot of those type or race discrimination or sexual harassment claims? Have they been impacted by the pandemic?
I mean, that's a good point. I would think to some extent, probably, yeah. Just because you're not having people interacting in person together, it just sort of takes away that element of it. So it probably has been a decrease of having people separated.
And
you're not
harassed virtually.
Yeah, and people aren't engaging in. A lot of times what I'll see is, and here's one of the things I usually really try and advise my employers.
This is a PG-13 show.
I know.
So you do have a little bit of license.
Okay,
but,
I'll try and
keep
it clean.
Yeah, come on, Laura. Let's
yeah,
I know it's your first podcast, but let's keep this.
No,
yeah.
I could tell some stories, trust me, but I won't.
Okay. But we are PG-13, so we're not entirely G or PG. I mean, we can do it,
Yeah.
Right?
No, but I would say is a lot of times you have people in the workplace and they're together and they're bantering around and everything is just hilarious and they're laughing and joking and but it's sex oriented, and it's like I said, it's all everybody's just thinking it's funny and fun and games and everybody's bantering around until it's suddenly not. And then you've got somebody that, they get fired and then suddenly they're saying, well, I was subjected to all of this. And even though it seemed like I was playing along, I was really offended, but because he was my boss, I wasn't going to say, stop telling those kind of jokes. So you've got to really be mindful of that and just be smart and don't make yourself vulnerable to having those kind of things turn on you, because you're going to be thinking that, oh, this is all funny and hilarious, and they think so too until they don't. And so really you shouldn't be having those kind of discussions in the workplace and that kind of banter anyway. So just don't. And I often get called a big wet blanket because I'm no fun. And somebody once called me the fun police. It's like but you can. It just makes you vulnerable. And you want to have a nice place to work, and you want people to have fun and to be able to get along and that kind of thing. But there's just lines that can't be crossed. Same with touching. I usually say there's no reason to ever touch one of your employees. Just don't. I know a lot of people are huggers and they mean things very
Is it okay for
innocently.
discipline?
Well, no, don't do that either.
Is there an exception for?
Yeah.
No. Okay.
No, but you got to be careful because people will, say, oh, he went to hug me, but he really hugged me really tight and he was pressing against me, and then it got all, and the guy's going, I was just going to congratulate her on meeting her goals for the month or whatever, and so it's like, don't congratulate her, but do it from across the desk. Sure. So those sorts of things, I think, and I don't know how I got off on all of this.
Oh no, I think we. No,
but
I
think
you,
it's
so.
You've just got to be smart, and it's really important to have policies in place that prohibit all of that, and then actually follow through and follow your policies and train your managers on the policies to where if they see something like this going on, well, first of all, that they're not participating, and if they see something like that going on, that they're stopping it. And again, they can be the big wet blanket, but they need to be. And because what'll happen is, or maybe it's you and me bantering back and forth and joking around, and Heidi's over here. She's not participating, but she's offended, she's tape recording you.
You're not calling her the big wet blanket?
No.
Okay.
Yeah.
Okay.
But that's the other thing too. Everybody's got recorders on their phones, so they're tape recording things, and it can just be really ugly.
Nice evidence.
So yeah, oh yeah.
So I mean, office. I can definitely see that offices develop their own culture, right? And it's hard to know. It's hard to know from the inside that your ship has left the dock and has floated that far out to sea until they see it in the pleading, right? Until they see that, oh my God, we did this,
right?
And by that point, it's probably a little too late.
Yeah, I mean, it's going to be hard, and you're suddenly finding yourself where you're having to defend yourself.
Mm-hmm.
So, again, if you kind of don't get yourself in that vulnerable situation to begin with, that's what you need to do. And a lot of it is training your supervisors. They need to know to recognize things.
It comes from the top.
Yeah, and it's important. So it's good. It's good to have policies, but the courts, they also want to see that you're training everybody on the policies. If the Department of Labor comes in and there's some sort of complaint, they want to see where's your training. When did you train these? So that's really important, because a lot of times too, a supervisor, somebody may come to a supervisor maybe and say, "Hey, look, I'm really offended by John's conduct. I feel like he's harassing me," and the supervisor may come back with something like, "Oh, whatever, it's fine."
I'm about to triple wow you here.
Yeah.
I'm about to quadruple. You are gonna.
Okay, well, I was just going to say, you don't want your supervisors blowing people off and acting and minimizing it. You want them to know, okay, this needs to go to HR. You need to go to HR, because if they dismiss it or disregard it, then you've still got a potential claim, and then there's a problem.
So I'm not. Actually, what I'm about to say is not as impressive as I thought it was a minute ago.
Okay.
But the McDonnell-Douglas balancing, or the McDonnell burden shifting test. Yes, that's where it's like the tennis match.
It is.
Right, where the employee says, "You fired me because of XYZ," and the employer says no. Right.
So
and
here's my legitimate, non-discriminatory reason why I fired you. And then the ball bounces back to the employee to say, that's not true. That's just a pretext. And you really fired me because of my age or race or sex or whatever.
And another thing too that's important is that when you're talking about harassment, there are. Right, you can have harassment that's what lateral, right? That's coworker, and that exposes the employer to liability. But when it's vertical, when it's the boss or a supervisor, that is super bad news, right?
Right.
Can you talk about that?
Yeah. So that's if it's a supervisor harassing a subordinate, then and there ends up being a tangible employment action. So the subordinate gets fired, or they're demoted, or their pay's cut, or whatever. Something bad happens, then it's really per se liability for the company. So if it's a supervisor, if it's coworkers, then it's more of a negligence standard, and you can have some defenses if you have policies in place to prevent it, and the employee didn't take advantage of the policies, or you knew about it and didn't do anything, that would be bad. So it's a different test, but yeah. And again, that's why you got to have your supervisors.
Yeah,
trained.
because if they're the ones that are the guilty parties, right? And that's what the plaintiff lawyer is looking for. If they know what they're doing, they're wanting to make sure that, okay, oh well, this guy is ahead of you, and because it's a lot harder to complain about the boss, right? The boss is charged with probably knowing a little better, I would think.
Yeah,
that's kind of
should
part
be.
of it. So there's a lot of reasons for that, and the boss can basically say, well, you're not playing ball with me, so I'm going to fire you, or I'm going to demote you, or whatever.
Yeah, your coworker isn't probably going to have the authority to fire you. So that's if you've got somebody who has authority to take those kinds of actions. That's what, and there's whole case law out there on what it means to be a supervisor, but that's ultimately it, is do you have the ability to take some sort of action against the person? Because that's what makes you vulnerable, is, well, if I don't say yes, he's going to fire me, and I got 3 kids at home, and blah, blah, blah. So
you guys can just argue about it. So you can argue about what a supervisor is. You can argue about, is this a contractor or not? This is just, I'm just thinking dollar signs. I mean, I don't know why I did criminal law. I mean, it's fun. But I don't know. I'm kidding. Okay, so let's talk a little bit about you and your background. You said you were married to a veterinarian.
Yes,
Okay, and you said you told me you wanted to be a veterinarian.
I did.
And so you just work with different kinds of animals now.
Right.
As a lawyer.
Exactly.
Okay. Give us a little bit about your background. Where are you from? Who is Laura Calhoun?
Oh, wow. Okay. Well,
Frame it that way.
I grew up in Houston. I've been in Texas all my life. I went to Texas A&M, so gig 'em. All right.
It's okay.
I went to Texas A&M, then I went to law school at South Texas down in Houston.
Okay.
I met my husband while I was at A&M. Like I said, I originally wanted to be a veterinarian. That didn't work out for me, so I kind of went with my next plan, which was to go to law school. So, again, went to South Texas, and then pretty much right after I graduated, we moved up here. And
that's a bit of a surprising track. I think surprising is probably not the right word. But, okay, so
all right, you want the true story of how I actually picked to be a lawyer?
No, I want to be lied to repeatedly. That's what yes, now we're going to see. It took us 40 minutes.
I know.
But we finally got there. Okay,
and
let's have I want the truth.
Okay, well, I'll tell you. I mean, I used to be, it was I really wanted to be a veterinarian. And so I was pretty devastated when I didn't get in. And that was hard because I had put on kind of all my focus had been on that. And so it was really tough. And I was kind of at a loss of, well, what am I going to do now? I've got this science degree, and I don't do well at the sight of blood, so medical school was kind of out.
Well, animals have blood.
But for some reason it doesn't bother me.
You can
in the veterinary.
That.
Yes.
Okay.
So I was talking with one of my friends who also did not get into vet school. And I was like, what are you going to do? And he's like, well, I'm going to law school. And I was like, law school? I was like, you're a science major. And he's like, well, I'm going to be a patent lawyer. And he said, law schools, they love science majors. He's like, you can do anything with, there's all kinds of fields of law where science you could do, medical malpractice, defense work, or, there's just a lot of health law, patent law. So it just never really dawned on me that law school would be an option. And so when he started talking about it, I was kind of like, oh, well, I can do that too. And so I just shifted my focus, and I never looked back. And I love it. It ended up being a really good thing for me. Employment law is just fascinating.
Much less blood.
Much less blood, yeah. So I'm obviously not doing anything with my science degree, but
it's okay.
But it gave me options, So it's been good, and I've been able to vicariously be a veterinarian through my husband.
Well, okay. So I guess so. And does he? And he's local then?
Yeah.
Okay.
He's a great veterinarian, by the way.
Well, you want to give him a plug? That's fine.
John Calhoun, North Carrollton Veterinary Hospital.
He's
great.
Where are they?
Carrollton.
In Carrollton. Okay. I have seen, and so we were talking a little bit too, because I always thought that I always thought that there was one and only one veterinary school in the state of Texas, and I don't know, maybe that used to be the case.
Yes.
You're saying there's three. There's A&M, Texas, and now Tech has one for big animals.
Yeah, no, Texas doesn't have.
They don't.
Yeah, it's A&M, but Texas Tech is opening, and I don't know if they've already opened or if it hasn't just opened. It's
Farm
going
animals
soon.
are big up there.
But
I know I'm alumni, so.
Okay. Yeah, that vet school, they're kind of focused on large animal vets, is my understanding. So I'm not the expert on that, but that's my understanding. So because there's a real need.
And we were talking earlier that's kind of the niche that you developed. Let's talk about how you got into employment in employment law. When did you make that? How did that happen? What's your trajectory there?
Well, again, I'm going to be honest. I hadn't put a lot of thought into it.
I'm worried now that we've been lied to here for the last 43 minutes.
No.
Okay.
No, and I'll tell you, I always get concerned when if you're in a deposition or something and you ask the question, the person's like, well, to be honest, because you usually think, okay, they're about to lie. But,
right. No, they've been lying.
Yeah. So, but I got out of law school, and I was offered a job by a guy who practiced employment law. And so we were moving to Dallas, and I'd been working for a firm down in Houston. And like I said, my husband and I got married right when I got out of school. He got a job up here. We decided to move up here. I needed a job. So the firm I was at, they said, oh, we have a former associate who's got a practice up in Dallas, and he needs somebody, and we'll give you a recommendation. And he did employment law, and so I dove right in and started learning it.
Have you always been employer side?
No. In fact, my first job, I worked there for about 10 years, and we did all plaintiff's work. So,
Okay.
And he had a very busy practice. It was a lot. And so I got a lot of experience on the plaintiff side. And then when I left there, I had my own firm for a little while, and I teamed up with a couple other lawyers for a little while, and we kind of did a mix of plaintiff and employer side. And a lot of it was, from my plaintiff days, I learned a lot that employers, I think a lot of them, they don't intend to violate the law. They just don't know. And so I kind of tried to take the approach of being proactive and helping employers prevent the lawsuit, do things right from the beginning so you're not finding yourself sitting in a deposition talking about why you hadn't trained your supervisors.
Right.
So trying to do some of that preventative law. And I still do a lot of that's a big part of my practice right now is I take calls of one of my old bosses used to say, he's like, you're like the bat phone. People call
Sure.
and say, hey, I need to fire this person. Is there any, how should I handle it or whatever? So I kind of talk them through and look for any red flags and that kind of thing. So I like to think that I'm helping people and
Sure.
and really from both sides by doing that because sometimes an employer will call and say, I want to do this, and it's like,
And this is why people don't understand. All lawyers go to heaven, all of us, because we're all helping somebody, right?
I try.
Except
Yeah, I try.
prosecutors and people who represent insurance companies. Everybody else is going to heaven, which is most of us, right?
Yeah.
Well, you guys may do insurance. You guys may do insurance-related defense.
I do, well, some.
I shouldn't say. Okay, so, but you do enough. I'm kidding.
Yeah.
But okay, so, but in all seriousness, a couple points here. Number one, just so the jury understands, I think there's very rarely you don't see a lot of solo practitioners or small groups that handle employer side, and my guess is that's for the reason that at bigger groups, bigger firms, you're going to have the infrastructure to handle more complex, to handle more bulk work.
Right.
Frankly, for lack of a better word. And the other part of it too is that, and let me bounce this off you. You tell me what you think about it. I mean, because we've got our law firm, and I've been the guy who fires people.
Yeah.
Which when that's you, everybody. I mean, what I've found is that folks sometimes get nervous when you shut the door, which is fun for a little bit sometimes, and you're just like, no, I just wanted to talk to you about the New Year's Eve party, and you say things like that, but and the person, sigh of relief there for you, but in reality, I mean, I've always operated under the premise that people who like you or people who are angry at you will not come back and make your life miserable, and so you always need to conduct yourself or do your best to conduct yourself with as much class as you can.
Absolutely.
But on the other side, I mean, I've also been in the position where, I mean, what is it? House guests and fish after 3 days, right?
Yeah.
I mean, so I've learned some hard lessons too, where, maybe a lawyer wants to go and head off and do their own thing, and we wish them luck, and then I'm looking at my computer, and my Dropbox has 847 things that just got deleted. Sometimes people take a little too much, or they, and then I call it dancing with the Ewoks, which is, they're going to go and then it turns into, after 2 or 3 days, they start talking to other people who are with me in my firm, and they say, this place sucks. We're going to go over here and we're going to have all the fun in the world, and you can stay here if you want. Mm-hmm. And you kind of got to get that out from, as much as you want to keep that former employee happy.
Right.
You can't really, it sort of poisons the well. Do you run into a lot of this?
I mean, yeah, it can happen. What I see a lot is somebody's a problem, somebody's a problem, somebody's a problem. You're kind of letting them slide, you're letting them slide. Maybe you're even giving them a great performance review because you're just trying to be nice or whatever.
If I'm nice to them and I put it in, then they'll live up to it.
Yeah, something like that. So I do see some of that, and then it just gets such a problem that it really could have been either corrected earlier by some counseling and here we can't be having this in the workplace. So I think there's a lot of times a inclination to, oh, they'll do better, it'll go away, and it just doesn't, and it gets worse. So.
Yeah, and I've had with our group. I mean, sometimes too, if we let it slide, everybody else gets angry at me.
True.
Because then it turns in what, Heidi?
Yep.
Just hitting close to home. Yeah, this doesn't happen at our office. But yeah, you let it go, and then everybody else is like, well, why does she get to get away, or he get to get away with this? And
that's a problem. If you're letting him get away with it and you're not letting her get away with it, then it becomes, well, what's the difference? Is it gender? Is it, so that's another problem with not neutrally, uniformly enforcing your policies. Is you can't let somebody slide and not somebody else.
No good deed goes unpunished.
Very true.
There you go. And with an iron fist, you have to control with an iron fist. That's the takeaway I get from this with you.
Well, no, you do need to be
the wet blanket, the iron fist.
Yeah. No, you need to be a wet blanket, and you need to be uniform in enforcing your policies for sure.
And okay, so another question I have in another area is too, because you can also see, like, if somebody says they're targeting me, right? Like a plaintiff who comes and says they're targeting me, and then your client is there, and they play the game of, when your client knows that they want to get rid of them, they start papering the file, right? And then the plaintiff says, well, you papered this file and none of the other 17.
Right.
Right. That becomes an issue too.
That can be an issue, yeah. Again, if you're not, and that's a lot of times what you see from the plaintiff's side of it is, well, wow, right after I complained about sexual harassment, then suddenly they put me under a microscope and they started documenting every little thing I did, which before they never had a problem with, or they're not documenting everybody else who's doing all the same thing, and that's a problem, and because. That's the other thing, employers, they need to keep in mind that, if an employee feels like they're being discriminated in the workplace, it is absolutely their state and federal right to go and report that, and they should. And so employers need to remember that look, and they should want somebody to report, because if there's a problem, I mean, they need to know about it, because they can't fix it if they don't know about it. So unless it's something that's just severe and pervasive and really obvious, a lot of times the employer will have no idea what's going on. So it's really important for the employee to know, again, have your policies. If you feel like this is going on, you need to report here, that they've got a place to go, and that they won't be retaliated against. So that's the other thing, is sometimes, an employer might be really offended. Like, I can't believe she's accusing me of sex discrimination.
I'll show her. I know the rules.
Yeah, and then they get mad, and it's like, you've got to put that aside and say, okay, look, if this is how she feels, we need to investigate it and figure out what's going on and resolve it, and she needs to be not retaliated against because of that. So that's just something else to kind of keep in mind, and that's where you start looking at, well, are they suddenly putting you under the microscope and documenting you for every little thing and trying to shove you out the door? Because that makes for a good retaliation case. When maybe even her underlying gender discrimination case fails, she can still have a valid retaliation claim if she's retaliated against because of that. So if an individual comes and says sexual harassment or race discrimination, any of the protected status,
and they go to the supervisor and they say, you guys are racists, and then the supervisors say, well, nobody calls me a racist, I'm going to show you, I know the rules. Bang, that's going to be retaliation for a race protected claim.
Yeah, I mean, that's a problem. Again, if especially, again, you get into legal things, if they've got to take some sort of adverse action against you. But if there's some
Right.
adverse action against you because you've made a complaint, then that makes the employer vulnerable to liability
Right.
there for a retaliation claim. So,
I'll tell you an odd story. So one time, so I used to be in the Army. You can tell because I'm the Iron Fist.
that's right.
I used to be in the Army, and man, this was not. I was a cadet. I wasn't even in the Army. And I got a splinter in my hand, hurt like the dickens, and they took me to the hospital. They took the thing out, and they just didn't want to get it infected. And the guy at the hospital says, "Do you want to file a workers' comp claim here? And here, sign here, here, and here." And I'm like, "I don't care, whatever, sure." You know, I fill out the thing, and holy shit, you would have thought that I mean, they got so bent out of shape that I filed a workers' compensation claim. It's illegal for people to be fired for filing for retaliation on workers' compensation
Yeah,
claims.
there's a statute. It's part of the Workers' Compensation Act, as you can't be discharged or in any other manner discriminated against because you filed a work comp claim or you got hurt on the job and sought advice.
Why does that upset an employer so much? Because I was like, my God, I can't believe you people are this angry at me I just signed the damn thing. The guy gave it to me, and I don't know that I ever got a nickel out of it, but
yeah, I don't know. I mean, that's why you have work comp coverage or insurance to cover those kind of claims. So
yeah, I guess your rates go up or something
it could
like
be,
that. Okay.
But yeah, there's a special statute that governs that, so you're protected there as well.
So what have we not? I feel like we've been very thorough here. What have we not covered? You've got a lot of. This is a lawyer's notes that I see.
Yes.
I type up an outline 3 or 4 days. Yes, actually last night in this instance. I'm not quite as always prepared because I always feel like if I'm inviting you on any guest, if I feel like I'm inviting a guest on, it's like I don't want to be like, here, have some homework too, come up with an outline. So I always kind of try to generate one. But yours, you've made a lot of notes.
Yeah, I think I've actually touched on them all too.
Okay.
You kind of covered a lot of ground here.
I think your paralegal must love you because do they have to interpret this?
Yeah, I hope nobody has to read my handwriting.
Not this one, but yeah, okay, all right. Okay, favorite thing to do as a lawyer?
I think probably helping people solve their problems. You know, really when an employer calls and they've got something that they just have no idea what to do, and I'm able to say, well, here's what the law says, and here's what you need to do, and then, you know, they're like, thank you so much. It makes you feel good when you feel like you've helped somebody. I think that's my biggest thing.
Not winning summary judgment?
I like winning summary judgment too. So that's probably my second favorite thing.
Okay, very good, very good. I tell people that winning is okay, but man, I hate losing. I don't know.
I agree too. I don't like to lose. And I think kind of on that point, just going back a little bit to my story about how I ended up being a lawyer. You know,
are you going to be honest with us now?
Yeah. No, but I used to be really embarrassed by the fact that I didn't get into that school. And it would be something that, you know, I never wanted to talk about and didn't really want to admit. And it's interesting, you know, as I've gotten older and I've got my 2 kids and trying to talk to them about what they want to do with their lives and whatever, I've found that I've been able to use that as a source of like, don't give up, don't be discouraged, you know, just because you don't get to do something that you really think you want to do, it doesn't mean, you know, your life's going to be terrible or you're not, but don't give up. And you know, I think the first time I told my kids that story, they were kind of like, wow, Mom, you know, we never heard that. And but it's just, I don't know, I feel like I've been able to kind of use that to encourage at least my kids when they get frustrated. It's like, don't get frustrated. Not everyone's going to get into vet school or medical school or law school, and it's okay.
So you're approaching it from a standpoint of we can, you know, from a Zen, we can do something different, whereas like I would take that as now I'm going to crush everybody and show everybody how mad I am at all this. Like
Yeah.
you look at what I'm trying to say is you've dealt with this quite constructively, whereas like Richard Nixon, you know, they if you've ever watched that movie, they say that the Constitution's dangling in the wind because he didn't make the varsity football team, right? And it can be that type of thing can be healthy to a degree, right? Tom Brady uses as motivation the fact that teams passed him over. But yeah, you know, I mean, there's just a lot more to life than certain things that we think are important.
Right.
And you know, I mean, and not only that, but we change as people. I mean, you know, I didn't know I was going to have such an amazing podcast. I thought I was always going to be this lawyer that was in trial and just wowing. And so I had a jury earlier this week. So I've been I've been doing this as kind of a cathartic way to pass the time until I could get back in jury trials. And I'll tell you, when I was jury sitting, when we were waiting for the verdict,
Always a fun time.
yeah, and I tell you what, I mean, I just remember thinking, God, I really don't like this part. I just really don't like it, and I'm not going to jail if I lose, you know. I mean, so I'm just the lawyer. But anyway, you know, that part. Of course, I won.
Good job.
This is my podcast. Okay, so anyway, this has been a very successful episode of the Lawyer Show podcast. My co-counsel today has been Laura Calhoun. I'm Jeremy Rosenthal. I'm your lawyer. Thank you again, everybody, and we will see you later unless we don't.
Yeah. Thank you, Jeremy.
Bye-bye.